Okay, Assalamualaikum warahmatullahi wabarakatuh to our beloved lecturer, Prof. Madya Dr. Nazli. Today we would like to talk about cyber law and online censorship in Malaysia. Cyber law refers to the legal framework that governs online activities and digital technologies. In Malaysia, it plays a crucial role in protecting individuals, business and government from cybercrimes, data breaches and online scams. On the other hand, online censorship is a key aspect of Malaysia's cyber law. Its purpose is to safeguard national security, public order and social harmony. The government has implemented measures to monitor and regulate online content created by users of digital technologies. However, discussion arises concerning the potential impact on freedom of speech and access to the information. Finding a balance between security and the protection of fundamental rights remains a challenge in Malaysia's evolving digital landscape. The Malaysian Communication and Multimedia Commission (MCMC) is responsible for regulating online censorship. They have the authority to take legal action against individuals who violate the set rules, block websites, and remove or restrict access to the content. Now, I would like to discuss the legal justification surrounding online censorship in Malaysia. Online censorship in Malaysia has raised important legal concerns. Section 3 of the Communication and Multimedia Act of 1998 guarantees no censorship of the Internet. However, other provisions and regulations provide legal justification for online censorship. The Malaysian Communication and Multimedia Commission (MCMC) has the power to control and impose restrictions on internet content. They guide local internet service provider ISPs to limit access to certain websites or blogs. Online censorship policies aim to protect against cybercrimes, safeguard public information, and respect cultural and religious sensitivities. The MCMC monitors and regulates online content to achieve this goal. However, concerns have been raised regarding a potential infringement on the right to freedom of expression protected under Article 10 of Malaysia Federal Constitution. Blocking websites and blogs may limit access to information and restrict the open expression of thought and opinions. In conclusion, online censorship in Malaysia is a complex issue.
Malaysia, the government online censorship policies have raised concern about the constitutional right to freedom of speech. While the government justifies censorship for reasons such as national security, social harmony, morality and privacy protection, it is important to ensure that these limitations do not unreasonably restrict freedom of speech. Comparing approaches from other countries like the United States, Canada and Germany can provide insights for Malaysia. The United States prioritizes free speech but restricts categories like obscene language and child pornography. Canada focuses on balancing social objectives and individual rights with restriction on hate speech and violence incitement. Germany has strict regulation to combat hate speech and fake news. To protect rights and freedom of speech in Malaysia, a precise legal framework should be established. Subject to judicial review and transparent processes, judicial control can prevent abuse of authority and public consultation involving various stakeholders is crucial. Limitation on free speech must be reasonable and necessary, and Malaysia can learn from comparative analysis to promote transparency, proportionality and judicial oversight.
While considering a comparative analysis, it is essential to note that different countries have a various approach to online censorship, such as the United States emphasizes freedom of expression and limited government regulation of online content, while there are laws addressing specific issues such as intellectual property infringement and illegal activities. Content-based restrictions are subject to scrutiny under the First Amendment. Online platforms have a broad discretion in moderating content. So the next country we're going to talk about is United Kingdom. The United Kingdom has a regulation in place to address harmful online content such as the online harm white paper. The proposed legislation aims to protect individuals from online harms, including terrorist content, hate speech, and child exploitation. It established a regulatory framework to hold online platforms accountable, reformed by Online Harm White Paper UK government. So next is the China country. So the China approach to online censorship is characterized by its extensive control and regulation of internet content. The Great Firewall employs the sophisticated technologies to block access to certain foreign websites and heavily monitor online communication. The Chinese government aims to maintain political control and restrict the flow of information. So next is the German country. So Germany introduced the Network Enforcement Act, NetzDG, which target illegal content, hate speech, and fake news on a social media platform. The law requires platforms to remove such content within specific time frames. Critics argue that the law places too much responsibility on the private companies and may lead to the over-removal of legitimate content. So that's the 4 countries that I'm going to discuss. The next are the 4 countries we will discuss by my friends Akil Akmal. Thank you very much.
Okay, for the next comparison is Iran. Iran is known for its strict internet censorship policies. The government heavily filters and blocks websites and social media platforms deemed inappropriate or a threat to the regimes. Citizens face significant restriction on freedom of expression and access to uncensored information. Okay, in Brazil, debates surrounding internet censorship and freedom of expression are ongoing. The country has the Marco da Internet, a legal framework that seeks to protect online freedoms while addressing issues such as privacy and illegal content. However, Brazilian courts have ordered the blocking of specific platforms or apps, challenging the balance between tackling harmful content and preserving freedom of expression. Okay, for the next country is Russia. Russia has implemented laws and regulations that grant the government extensive control over online content. The Yarovaya law enables to monitoring, filtering, and storage of users' data. The government has blocked access to critical websites and social media platforms, raising concern about limited freedom of expression and privacy. For the last comparison is Sweden. In Sweden upholds strong principles of freedom and expression and access to information. The country has a relatively open internet environment with minimal government-imposed restriction. Laws emphasize the importance of free speech, while restrictions on online content must be proportionate and comply with human rights standards. Okay. In our brief exploration of internet censorship, we observe that Iran and Russia enforce strict control over the online content, while Brazil faces challenges in finding a balance between tackling harmful content and preserving freedom of expression. On the other hand, Sweden prioritizes freedom of speech while addressing legitimate concerns. This diverse approach highlights the complexities of internet censorship around the world.
So now, I want to share about evaluation and analysis about online censorship. Online censorship in Malaysia is a complex topic that involves tension among constitutional protection provided by the judiciary and limitation placed on particular blog and website accessed by Malaysian Communication and Multimedia Commission (MCMC). This condition raises question about the constitutional and legitimacy of such censorship, especially in light of the right to free expression. Examining Malaysian current legal system, contrasting it with other judiciary methods, and considering potential future ways to deal with online censorship are necessary to get through knowledge of this subject. Article 10 of Malaysian Federal Constitution protects by liberty of communication as a basic right. It provides people to the right for freely express their opinion and thoughts, subject to limitation based on consideration of ethical behavior, public safety, and the safety of the country. The main concern is whether the MCMC internet censorship is too proportional and required in an environment of democracy. The constitutional right to autonomy in speech may be violated if the limits go beyond what is the appropriate and necessary. To make sure that limits are not arbitrary but rather serve a purpose that is legal and appropriate, courts would need to carefully examine each instance. For summary, due to the conflict between legislative protection and instance of limit enforced by the MCMC, online censorship in Malaysia offers a legal issue. Analyzing the legal rationale and potential violation of the freedom of expression clause in the Constitution is essential. Cooperative research of other countries' strategy for internet censoring can offer insight and make it easier to find methods that work well. It is essential to strike a balance between defending the public interest and respecting individual rights, which calls for open communication with stakeholders, consultation with stakeholders, and the encouragement of digital and media literacy. Malaysia can find a way to create an online environment that is more inclusive, knowledgeable, and democratic by negotiating this difficulty.
Malaysia's cyber law includes online censorship as a crucial part to safeguard public safety, social harmony and national security. The Malaysian Communication and Multimedia Commission (MCMC) can take legal action against those who post inappropriate content online. The government defends this by emphasizing the need to combat cybercrime and protect cultural and religious sensitivities. Critics argue that strict censorship can suppress dissent and hinder the free flow of information. Striking a balance between individual freedoms and security concerns is challenging. Malaysia's Communication and Multimedia Act of 1998 clarifies that legal framework but concerns exist about potential violation of the right to freedom of speech. Different countries have varying approaches to online censorship, with the US prioritizing freedom of speech, the UK aiming for a balance, Germany addressing illegal content, and China exerting strict control. Malaysia must navigate these strategies while protecting public interests and upholding constitutional rights.